There is a dangerous sentence people say when they think they have found the ultimate proof. I recorded it. That sentence feels powerful, final, like the argument is over. But in law, a recording is not magic. It is not automatically lawful, admissible, or safe to publish. And sometimes the very thing a person thinks will save them becomes the next legal problem. I am Polamopicus, and this is Polamopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
In the age of smartphones, live streams, voice memos, dashboard cameras, and social media drama, recording has become almost automatic. Someone lies? I recorded it. Someone denies what they said. I recorded it. Someone behaves one way privately and another way publicly? I recorded it. But the legal system asks harder questions. Was the recording lawful? Was consent required? Who needed to consent? What state law applies? Was the conversation private? Was the recording later posted publicly? Those questions matter because recording law is not simple, and in some situations, the very evidence a person thinks proves their case can create civil liability, criminal exposure, admissibility problems, or all three. Most people say two-party consent, but the more accurate phrase is often all-party consent. The issue is not always whether two people consented. The issue is whether everyone legally required to consent actually did agree before the recording occurred. Federal law generally follows a one-party consent framework. That means if you are part of the conversation, your own consent may be enough under federal law. But federal law is not the whole story. States may impose stricter rules, and some do. That creates the major distinction. One-party consent. If you are part of the conversation, your own consent may be enough. All-party consent. Everyone whose consent is legally required may need to agree before recording. That difference matters enormously because many people incorrectly assume, I was part of the conversation, therefore I can record it. That may be true in some places. It may be dangerously wrong in others. Most people do not record conversations because they are thinking like lawyers. They record because they do not feel believed. They think the other person lies, manipulates, changes stories, or behaves differently in private than in public. Emotionally, that reaction makes sense. Legally, emotional reasoning does not decide the issue. The law asks different questions. Was there a reasonable expectation of privacy? Was the recording secret? Was consent required? What jurisdiction applies? And was the recording later disclosed or published? Because recording is not just an evidence issue. It may involve privacy law, criminal statutes, civil liability, workplace policies, protective orders, harassment allegations, or admissibility rules. People think they are collecting evidence. Sometimes they are, but sometimes they are collecting liability. Massachusetts is often described as a two-party consent state, but the law is especially concerned with secret recording. The Massachusetts wiretap statute focuses heavily on secretly hearing or secretly recording communications without proper consent or authority. That distinction matters, because the very secrecy that makes a recording feel useful may also create the legal problem. People often think, if I warn them, they will stop saying the thing I need to prove. That may be true, but the law is not designed solely to make evidence collection easier. Privacy interests matter too. Needing proof does not automatically legalize the method used to obtain it. One of the biggest misunderstandings online is the belief that if the recording is true, then everything about it must be legally fine. That is not how courts work. A recording may accurately capture a conversation, strongly suggest misconduct, or embarrass someone publicly. But courts still ask, was it lawfully obtained? Was consent required? Was it edited? Is it authentic? Is it complete? Does it violate another rule or order? Truth, evidence, proof, and admissibility are not the same thing, and internet reactions are not evidence rulings. Online, people hear a clip and reach a conclusion immediately. Courts care about process. That difference is critical. Myth 1. I was part of the conversation, so I can record it. Maybe. The correct question is, what law applies? Myth 2. They were yelling, so they had no privacy. Not necessarily. Bad behavior does not automatically eliminate legal protections. Myth 3. It happened in public, so I can record anything. Again, not automatically. Public location may matter, but it may not end the legal analysis. Audio and video can also be treated differently. Myth 4. They lied, so the recording is justified. That is emotional reasoning. It may explain why someone recorded, but it does not automatically make the recording lawful. Myth 5. I only posted it online. That may create additional problems. Publishing recordings can trigger harassment allegations, privacy claims, workplace issues, protective order problems, or defamation-related disputes. Sometimes the posting becomes more legally dangerous than the recording itself. This is where modern disputes escalate rapidly. Someone records, then they post, then they narrate, and audiences react. Then clips spread, and harassment allegations begin. Then the other side starts documenting the publication itself. What began as, I wanted proof, evolves into, why am I now accused of privacy violations, harassment, or unlawful interception? This is especially dangerous in custody disputes, restraining order situations, workplace conflicts, ongoing litigation, or creator-public trauma environments. People underestimate how quickly online publication changes the legal landscape. One of the most dangerous assumptions is, only my state law matters. That is not always true. When conversations cross state lines, legal analysis becomes more complicated. There is actual case law showing that a recorder's one-party consent state may not control when the other participant is located in an all-party consent jurisdiction. In Kearney v. Salomon Smith Barney, the California Supreme Court held that California's all-party consent law could apply to calls recorded from Georgia when the clients were located in California. In France v. France, claims were allowed to proceed involving recordings allegedly made from North Carolina involving a participant located in Florida. The larger point is simple. Interstate recording issues can create serious uncertainty and risk. The safest rule for interstate conversations is straightforward. Obtain consent from everyone before recording. Recordings can absolutely matter. They can preserve admissions, document threats, capture misconduct, and protect against false narratives. But recordings are not magical legal immunity. The legal system still cares. How evidence was obtained, whether rules were followed, whether privacy laws were violated, and whether publication created additional harm. A person can expose bad behavior, can still create legal exposure for themselves. A person can win the internet and lose the legal argument. The phone in your hand can capture sound, but it does not grant legal permission. The record button can preserve words, yet it does not erase consent requirements. The upload button does not transform social media into a courtroom. Two-party consent laws are not technical trivia. They are legal boundaries. Before you record, know the law. Before you post, know the risk. Before you call something evidence, understand that evidence must survive process. Sometimes the most damaging recording in the room is not damaging because of what the other person said, but because of what the person recording did with the recording.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.